Did you know that as a consumer, you have legal protection from fraudulent and deceptive business transactions, including the right to a full refund when businesses fail to deliver services you have already paid for? And why does this matter? Here's the law. You swiped your card. You paid for a product or a service. It never arrived, or it arrived broken, or even worse, it was nothing like what was promised in your advertising. You call the company, you email them, you beg. They promise to look into it. Then they ghost you. Their delay tactics and frustrating stalling are designed to do one thing: run out the clock until you give up. You feel powerless. But you're not powerless. Here's the law. Consumer protection laws exist to protect you, and you don't need a lawyer to enforce them. Today, we're going to walk you through exactly how to fight back, step by step, so you can get your money back and hold bad businesses, accountable. All right, let's start. Let's start with the most important rule. Stop talking to them. I know, it sounds counterintuitive, but scammers and shady businesses use ongoing dialogue to string you along past the bank dispute deadlines. Every day you wait, you lose your leverage. Here's what you need to do instead. Compile a timeline. Collect every piece of evidence you have: receipts, orders, confirmations, emails, text messages, and screenshots of the ads or refund refusal. Track the paper trail. Log the times, the date, and exact names of any representatives you speak or spoke with during the transaction. Why does this matter? If you end up in small claims court, your evidence is everything. Judges don't care about how you felt. They care more about what you can prove. Facts versus feelings. A powerful tool in Ontario. If you bought something online, over the phone, or at your door, you may have a cooling off period, a specific number of days during which you can cancel the agreement without reason or penalty. You can cancel the contract anytime within the cooling off period by writing a cancellation letter. The key word here is writing a cancellation letter. Don't just call them and say, I cancel. You want to put that in writing. Under the Consumer Protection Act, when you cancel, the businesses has 15 days to refund your money. If the seller refuses and used unfair practices, you can cancel the agreement within 1 year. And if you paid by credit card, you may have additional protections. So document everything before you take the next step. Now, let's talk about the fastest way to get your money back: the chargeback. Call your card issuer immediately. Dial the fraud or customer service number on the back of your debit or credit card. Tell them the businesses misrepresented the product, failed to deliver, or refuse a legitimate refund request. Request a formal chargeback. This is not a dispute. It's a demand. You're telling your bank to reverse the charge because the merchant breached their obligation. Watch the clock. This is where scammers try to delay you. Most credit card networks require you to file within 60 to 120 days of the transaction. Most creditors have deadlines between 30 to 60 days. Check with your card issuer. In Quebec, for example, The Consumer Protection Act gives you 60 days from the merchant's default to request a charge back. If you use PayPal, open a dispute directly in their online resolution center. If you paid by debit or wire transfer, the process is harder, but not impossible. This is your strongest, fastest weapon. Use it immediately. If the bank can't recover the funds, it's time to bring in the regulators. Report deceptive marketing to the Competition Bureau. The Competition Act of Canada prohibits misleading advertising. It's against the law to make materially false or misleading representations to promote a product or a service. The Competition Bureau investigates false or misleading advertising claims. You can share information with them online, and your complaint helps them identify patterns of misconduct. File a complaint with your provincial consumer affairs office. Every province and territory has a consumer affairs office that can investigate and help resolve disputes like these. If the businesses have a physical footprint in your area, this can trigger a regulatory investigation ASAP. Submit a complaint to the Better Bureau Business BBB. Legitimate companies will often refund your money simply to get a BBB complaint cleared. It is a reputation hit they want to avoid. Just remember that, okay? Further, report the scam to the Canadian Anti-Fraud Centre, CAFC. The CAFC receives fraud reporting from Canadians targeted and victimized by fraud. Your report helps them map illicit patterns and warn others. A consumer alert. Be aware of a third parties asset recovery or fund clawback firms that can reach out to you online in some attempts meant to help you. But these are almost always secondary scams designed to charge you heavy upfront fees for sending simple demand letters you can easily write yourself. So pay attention so that you're not scammed twice. If all else fails, you have a powerful final option, the small claims court. And here's the good news. You don't need a lawyer to go to a small claims court. Small claims court is designed specifically for self-represented litigants. It uses simplified procedures, relaxed court rules of evidence, and lower costs. The monetary limit, for example, in Ontario, as of October 1st, 2025, the small claims court limit increased from $35,000 to $50,000, exclusive of interest and costs. This means most disputes can be resolved without a lawyer, faster, cheaper, and simpler. The timeline. Small claims court cases typically resolved in 6 to 12 months, compared to 18 months to 3+ years in Superior Court. How do you start? Well, just go straight, download the forms from your provincial court website. Pay the filing fees, usually under $200. Serve the defendant, gather your evidence, and show up. The deadline, you generally have 2 years from the date you discovered the scam to initiate this process, especially if you're going to small claims. Now, before we wrap up, a critical warning. Be highly alert to third-party asset recovery or funds clawback firms that reach out to you online, as I mentioned earlier on. These are almost always secondary scams designed to charge you heavy upfront fees for sending simple demand letters that you can easily write yourself. You don't need to pay someone to write a demand letter. You don't need to pay someone to file a small claims court application. The forms are free. The process is definitely designed for you. Don't let a scammer profit twice from your loss. Got it? All right. Now, here's the law, and here is your move. Don't wait. Don't give up. Consumer protection laws exist to protect you. Start with a written demand letter. It's cheap, it's formal, and it often works. If you have been scammed, stop talking to the company. Log all your evidence, file a chargeback immediately, report to the Competition Bureau and CAFC. If all else fails, sue in small claims court. No lawyer required. You are not as powerless as they make you feel. You have rights, and you can enforce them. This is iChatLaw, where the law gets real. If you found this helpful, like, subscribe, and turn on post notifications. We post every weekday, Monday to Friday. Daily legal updates, daily empowerment. Until tomorrow, know your rights, protect your future. Now you know.